In most fact-finding investigations, talking to people who are involved or who can provide the important background will be an essential part of the evidence-gathering process. Where the matter raises regulatory or criminal issues, or just general litigation risk, managing the interview process to maximise usefulness, but also protection for the business will be key. And that means using skilled specialists who know how to limit the risks while also conducting effective interviews to get the required information appropriately and fairly. If there's a parallel external investigation into the same matter by criminal or regulatory authorities, then it's important to liaise with them before conducting interviews for your internal investigation to avoid any criticism or accusation of hampering the investigation. But more generally, subject to time and cost considerations, you can and should interview anyone who might have relevant information to the issues, whether because they have specific involvement or because they can provide useful background information or context. The obvious interview candidates, at least initially, will typically be employees of the business. They can be conducted while maintaining a degree of privacy and confidentiality over the fact and content of the investigation. That may also assist any claim to privilege over the interview, subject to other requirements being met. But there's far less ability to protect the confidentiality of an investigation and the issues when third parties are interviewed, such as ex-employees, customers, or suppliers. So careful consideration needs to be given to whether there's going to be overall benefit in interviewing them, balanced against the risk of loss of confidentiality and control.
In-depth interviews should generally be conducted after the investigation team has acquired a basic understanding of the subject matter of the investigation and the documentary evidence has been gathered. But it can sometimes be useful to conduct some initial interviews to help speed up the investigation team's understanding of the general background and chronology. This can also help in structuring the rest of the investigation. In the case of an expedited investigation or where other factors mean a delay may prejudice the investigation, for example, where there are departing employees or if you're facing regulatory scrutiny, you may need to go directly to interview with the best knowledge of the facts available at that time. Often it will make sense to interview more junior people before more senior people and witnesses before suspects and subjects to limit the prospect of re-interviews. It can also be useful to group certain interviews to take place around the same time to mitigate the risk of interviewees with related evidence talking to each other and affecting each other's evidence, whether inadvertently or deliberately. But in reality, the best order will be determined on a case-by-case basis. You should also think carefully about where interviews should be conducted. You may want to avoid the office for confidentiality reasons, but an external location may mean the individual feels ill at ease, and a law firm office may seem heavy-handed. Again, this needs to be determined on a case-by-case basis. In general, you should avoid showing interviewees any documents that they've not seen previously, as it may cloud their recollections and it could be seen by external authorities as tampering with evidence or prejudicing the investigation. And while it may be useful to tell the interviewee in general terms what the subject of the interview will be, it's generally not helpful to provide questions in advance, to avoid them rehearsing their answers or getting their story straight. Before meeting with interviewees, be clear on the purpose of the interview, the expectations of honesty and confidentiality around what is discussed, your role, and if a lawyer, who you represent. You should also explain how their evidence may be used in the future, and so far as possible, explain with whom their evidence may be shared, for example, with regulatory authorities. If the investigation is protected by legal privilege, explain this, and that the privilege belongs to the client, not the interviewee individually, and that the client may choose to waive that privilege if it deems fit. Set out the steps that will be taken to preserve confidentiality in the evidence provided and any limitations on this, for example, where production is compelled by law, if there's a disclosure risk in collateral litigation, or where regulators require material to be produced. Often it can be helpful to have a script to use at the start of each interview so that all interviewees get the same general introductory information and to ensure that you've given all interviewees the right information. Make sure the interviewee is comfortable with proceeding and avoid any risk of being seen to take advantage of the interviewee unfairly. For some interviews, such as suspects, it may be necessary for fairness reasons to caution the interviewee at the start, even if that may mean they are less willing to be open with you.
So one of the key issues will be who should conduct the interview. There really is no right or wrong answer here, or one size fits all. It will depend on the particular investigation. Issues to consider will include whether the interviewers should be internal or external, which raises important issues around independence and objectivity. Using external interviewers can bolster trust in the process, both in terms of internal witnesses and also regulators who may be keeping a keen eye on the investigation. Statutory employment law rights for interviewees to be accompanied under employment law do not apply where the meeting is an investigatory fact find, and where the subject matter is very sensitive with confidentiality paramount, it will generally be inappropriate for third parties to accompany the witness. However, there are always exceptions, and there could be cases where having someone to support the interviewee may be beneficial to the process overall. For example, where emotional support is required for vulnerable witnesses. It will be crucial to ensure that the attendance of a third party does not undermine confidentiality, and it may therefore be advisable to put in place safeguards, such as requiring an attendee to sign confidentiality undertakings before agreeing to their attendance. One common issue we see cropping up is the right to legal representation for witnesses in internal investigations. This can be a real hot potato and needs careful consideration. Lawyers should only be allowed to attend in fairly limited circumstances. Our general experience is that witnesses having separate legal representation at the fact-finding stage will slow down matters and result in the company losing a degree of control over its own process. Of course, if a witness will not attend without their lawyer present, then it may be better to allow that than not have the evidence at all. Similarly, if the interviewee is a suspect, then one has to consider wider issues such as fairness and the potential use of their evidence further down the line. In such cases, it can be positively beneficial to have the individual's lawyer present. Where an interviewee is afforded the right to legal representation, it's important to make sure that their chosen counsel is a subject matter expert, and it will also be crucial to ensure that clear parameters are set around the scope of any financial contribution to their legal costs.